When a client comes to us with a business dispute, our first objective is to identify what the client's business objective is with regard to the dispute. If the client wants to win at all costs, that business objective is going to drive a particular course of strategy with regard to that dispute, specifically probably litigation there. If a client instead wants to resolve their dispute as efficiently and as quickly as possible, it's going to drive a different path of resolution for that dispute, namely one of settlement. Most cases aren't on either end of that spectrum. Most cases are somewhere in between. And for us to determine what path we should take with that dispute, we need to know the client's business objective. And in order to know the client's business objective, we need to know their business. And as part of that, in understanding the case, we can then determine what leverage points exist, both in favor of our client and that the client can use affirmatively in their case. There are a number of different options available to resolve any dispute that comes to our office or otherwise. And litigation is a means of resolving a dispute in the courts. Another path, more frequently used, particularly in recent years, is arbitration. And arbitration is really just like a private litigation. It is no less binding than a judicial determination, but it occurs in a private setting. Another path of resolution is simply settlement. And one of the most effective means of achieving settlements is through a process called mediation. Which path a case takes and which procedural path a case takes depends again upon the client's business objective. If your client comes to you and says, we have this dispute and we want to get it resolved as quickly as possible, if you have the option, one of the most effective paths would be to mediate that case. Sometimes, however, mediation isn't the most effective means until there's some leverage established in the case, and you may need to litigate or arbitrate the case first. By contrast, if the client's business objective is to win at all costs, then there's one very clear path there. That is litigation. One of the most common misperceptions about arbitration is that it will be much more efficient and much less costly than litigation. And that is not necessarily so. Arbitration, probably as a general rule, is more expeditious than litigation. You will get a ruling more quickly through an arbitration process than you would from a court process. But it is not necessarily less expensive. In many cases, it's more expensive. A common misconception with regard to mediation is that it is a binding process, and that's not the case at all. Mediation is a facilitated process using the services of a trained mediator whose job it is to get the parties to come to an agreed upon resolution. And if one party doesn't agree to a particular proposal or to resolve that matter, mediation ends with no binding effect whatsoever. A positive outcome in a case is defined by whether or not the client's business objectives have been met. If a client comes to you and wants their case resolved as efficiently and as quickly as possible, that business objective isn't met by litigating that case from A to Z and spending more than the case is worth. So there really isn't necessarily one outcome that fits all sizes.